right? We're going to introduce some topics, global topics on online mediation and arbitration. We would like it to be a dialogue. And so as Nirupam is doing, you just keep chatting here. And if you want to share your comments, you raise your hand. Maybe that's the best way we go about this. So we make sure it's engaging and not us just sharing general insights. But with that, I give the mic back, proverbial mic, back to Rajat to lead us.
I'm so sorry. I think effectively, let's get the session restarted. And I think now that we are on track, first of all, welcome to both of you and a very happy Thanksgiving. And a very good morning to the two of you, because I understand that the time difference is such that as we near the end of the day, you're starting yours. So, Kabir and Rekha, how has your experience been during the COVID year, during this COVID year, if I can call it that? And what are your takeaways truly from how the year has progressed? How is it that the profession has caught up with it? How is it that the courts have reacted, the arbitral tribunals have reacted? And what's the way forward?
Rekha, you should begin. The words of wisdom from our intelligent woman.
Well, it's such a large question that I'm not sure directly how to respond. And what we will do soon after is we'll take you through a deck where we just have comments that we'll offer all collectively, all the speakers, and then sort of wait for your input. But in truth, I think resilience is what defines this period of lots of pivots. Appreciating that everyone has had to jump to the current speed at different levels, but notwithstanding, I think my biggest curiosity is I've been so impressed with how our community has been resilient to shift everything to virtual or to remote or whatever the apropos nomenclature is, which is a part of an ongoing dialogue right now with various international bar associations. What do we really call this? But, it demonstrates that as lawyers, we can be flexible and that advocacy can also shift. Of course, buzzwords remain, things like due process paranoia. Are we indeed still paranoid, even more so as we've gone virtual or remote? How do we, what are countervailing realities to that? And then finally, the question of, is it here to stay? Which is something that I'm always very curious about. Or will we indeed have some level of amnesia when the world comes out of hibernation in pandemic? And will we go back to our old and perhaps some of them worse ways? But with that, I'll pause and hand the mic to Kabir.
Kabir, before you begin, can I add a question?
Yeah.
I just in addition to what you think this year represents for our community, for our profession, do you think we need to or should go back to the normal as it used to be?
I'm going to give the lawyer's answer that it depends. I think 2020 has forced us collectively as a community to realize that we don't have to do things the way we have done them. Lawyers tend to be risk averse, and we had a way of doing things. It worked fine for the most part, and we were reluctant to change. In the last 8 months, we have suddenly realized, hey, technology can be utilized in such an effective way. I mean, just think of this reality. We're in two different parts of the world. Last year, an event like this would have been almost unthinkable. The idea would be everybody flies to New Delhi or to Mumbai and the event happens in person, right? Now,
Absolutely.
That's a great way of doing things, but there's something unique in the fact that we're all getting connected the way we are. On your question,
in our own homes.
Yeah, exactly. Totally. On your question specifically, look, I do think I'm going to pivot slightly back to what Rekha spoke about, Rekha mentioned that, this is positive. We're all appreciating the benefits. It's still, in my humble view, a little early for us to assess whether this is going to be a systemic change, whether this is going to be, a hybrid model that we're going towards, or whether this is going to be the future. Personally, I think we are going to come to some sort of hybrid model, smaller disputes. We're going to see greater appreciation for technology, this virtual setup. Larger disputes, I still think people are going to, Counsel is going to insist we want to do it the way we have done things. I could be wrong. In some senses, I hope I am wrong. But I think this is where I am right now, and I'll stop here.
So, I'll just add my 2 bits. One, I think the first and foremost, it's been a year of suffering, and
Yep.
unfortunate it has been. But at the end of the day, just as we've suffered, we've learned, and those learnings, I think, would definitely make us think once this tide's over. The need to go back to the earlier normal. There'll definitely be a push from within.
Yeah.
One of the ways to get over this would be to go back to the old. But then I think we'll ponder over our learnings, and we'll take our lessons with us. So I agree, some kind of hybrid model will emerge and should emerge. I think this is a large part of this is more efficient, must be adopted. We may be averse to adopting it, but we've learned the ropes during this difficult year. We've been able to slowly but surely make our peace with technology, learn it, imbibe it, and we are here having a conference, sitting in the comfort of our own homes, and at different times of the day, and it's definitely been a way forward. So may I request the 2 of you to please share the deck with us, and we can have this discussion as we go along the slides.
Sure. Give me 1 second. The system seems to be reacting strangely here, but just give me 1 second.
No, take your time. Rekha, in the interim, may I ask, how is it that as an institution you are looking at the way forward? What is it that you are going to be suggesting as an institution? Because you are the people who are going to drive the change when it comes to the practices that we as professionals adopt in arbitration.
Sure, and thank you for the question. I guess by way of background and full disclosure, I'm director of an institute called the New York International Arbitration Center. So it's an innovative body in that you don't see this across jurisdictions as much, but it's a think tank and center that's meant to promote the jurisdiction in which it sits. So for New York, promotion of application of law within arbitration, New York as a seat, New York as a venue, and responding to sort of inquiries. Similar ones exist, for example, in Maxwell Chambers in Singapore, but that's a chamber. So let's set sort of the knowledge base. With that, I will say in general, I think we're all, both institutions and think tanks in the arbitration space, are thinking really critically because they, I think, hold the reins in this. I'll note that right as pandemic started in mid-March, there was this flurry of activity from the institutions to try to tell the community, these are best practices, these are suggested protocols. And I'm happy to share that list with any of the delegates if they're interested via Babita or anybody else. But at NYIAC, we tried to compile what are all of the global sort of suggestions, right? Because we're all new to this in terms of having to do everything remote or in virtual. And so I think there were some certain standards the institutions set up, right? So what now, right? We are now in late November going into December, where pandemic is upticking again across the world. And so how are the institutions going to respond? Frankly, the biggest thing is that institutions will remain open, even against court closures. And so this notion of access to justice, I think, really puts a spotlight on international arbitration, that your case can go forward. Your claims will be heard. That's not even considering all the other permutations and issues like is the moving party able to pay all of its costs? Does it need to involve a third-party funder? What are all of the permutations there? Do we need emergency measures? The beauty is that all can be done now within arbitration and by the institutions outside of the courts, so long as there's compliance. I think the institutions are also really looking at this hybrid notion, right? Because we cannot say what the future will hold for sure. But I think institutions are really thinking about, let's look at our space. Let's look at the high-tech capabilities. Let's make sure that as we go into the future and come out of one day pandemic, what will the hearings look like? And in truth, I think they may involve more so a hybrid notion where counsel perhaps may really still want to be in person with the decision makers, but you don't need the experts or the fact witnesses on site. Will the process necessarily be more economical and efficient if we're able to compartmentalize like this? Because advocacy has been the tough thing we always talk about, where the advocates still want to be present. They want to be able to talk to a witness, but can we figure out how to do it better in virtual where not everyone is there? Or how do you do it? I think the institutions right now, frankly, are thinking about this a lot. And in the interim, when we have downtime, they are revolutionizing their rooms, thinking about what does having space mean? What cameras do we have? How do they connect? Do they have a 365 view, much like what we give to a witness to try to demonstrate that there's no witness influencing or tampering? And so the good lawyer answer is we have to wait and see because we don't know yet. But I do vest a lot of faith in the institutions. They have led us far in this process now, and they'll continue to. But I'll pause there.
That's a very interesting observation you make. So I think that's I hadn't thought of this, but this is truly a pitch for arbitration over litigation. You're right. I mean, the courts have been slower to imbibe these practices as compared to arbitrations, and definitely the business community is looking and positively looking at arbitration, and I think more so institutional arbitration, because you're right. The institutions were the first ones to rise to the challenge. Various SOPs were thrown about, and many an institution even came out with separate and newer rules. I think ICC is probably launching its new rules for 2021 in a couple of days. So and all of that is now accounting for the fact that a large part of the proceeding may possibly have to happen or be chosen to be conducted online.
This is true. And it also, speaks to there's great jurisdictional imbalance. Are courts open or courts not? What was the seat you picked? And are courts open at that site? But also, I have to add, in general, institutional rules are appropriately vague. They have always allowed for, this sort of video conferencing, video hearings. They've never limited it out. And so now it's more so to say, it was always there if you read the rules carefully. We just never embraced it because in truth, we were set in our ways of doing things and it worked, right? But where we cannot do things the way we always did, it doesn't work because we cannot meet safely. How are we going to do it? And as people, looked back to the rules, they realized they already had that flexibility. They just weren't zeroing in on it. And now the institutions, I think, with their advanced rules, new rules that are coming out, like the ICC, they're putting a larger spotlight on, in this era, it's pandemic. But it could be any number of other acts of God, right? As we say under the force majeure dialogue, any number of other things in the future. We don't know. And so much like this should equip us to figure out how we're going to do it and do it better, we have to be ready for the next thing. And the rules will remain that way, flexible and thoughtful, so long as we're looking to read into them well. But let's wait to see what the institutions will offer us in general. And I laud them, the administering institutions, because they have taken this role seriously. They've been put in the spotlight in many ways. They were put in the spotlight about diversity issues. They've now been put in the spotlight for pandemic. And I think they're rising to the challenge. But the truth is, and the last point I'll make before I pass the mic back to Kabir and to you is, the truth is it can never become a collective action problem. We must not allow it. Every stakeholder has to do their part, meaning we have to get agile in how we get online. We have to figure it out. We have to start with, making sure we have a stable connection. But we all have a role to play in not adding to the noise and the issues. It's not alone the institutions, but although they'll carry the torch. But we all have this sort of role to play. Are our outside counsel teams and our in-house counsel teams adept and able to join? If not, what are we doing to make sure technology is what it needs to be so we can conduct the hearings, that everyone is aware of the protocols in advance? They're very clear and set out. Just like in a procedural order, also procedures for virtual or remote hearing. And so I think there's a lot of things we're all doing that we just need to start to concretize, centralize, so it becomes part of the practice, that we no longer keep talking about the woes of being in remote hearing, but rather, this is it, we're in it. And so it's no longer new. We've been doing it successfully. But I pause there.
Kabir, may I request you to go to your slides and start?
Sure.
Would you also just shed light on what's your experience been? Has infrastructure been a challenge?
Sure. I mean, if you're talking about infrastructure in the sense of technology, that is a perennial problem, right? And I think it's a global problem. Internets go up and down. Very often you need to have 2 or 3 computer screens if you're doing a big hearing, right? You need one to put your documents, one to see the tribunal, one for the witness to see the witness. There is definitely a cost associated with it. The question I think that becomes is, can you offset the cost of flying if you had to fly to a venue? Very often these big cases tend to be seen in Europe. I'm sorry?
The total infrastructural cost is one flight ticket.
Yeah. So this becomes the question, right?
That's true. So,
do you see the slide deck in front of you?
Sorry? No,
do you see the slide deck? You do not?
No.
Okay, give me 1 second. Sorry, forgive me. It said it was sharing it, but let me just try it again.
Okay, I was muted. Sorry. Rajat, maybe you can respond to this question that was placed in the chat while Kabir brings it up. And Kabir, if you can't bring it up, we'll just talk through the deck.
Okay.
But Rajat, do you want to respond to this cyber hacking question and how you're perceiving it as an advocate? And then I can take it from the institutional side as well.
I'm so sorry, I didn't see the question. Could you please read it to me? I can't.
Yeah. So Avni asks, how can the institutions ensure ODR, online dispute resolution methods, are not interfered with by cyber hacking, which can compromise privacy? But I think her question, hacking and cybersecurity, is a larger one that we're all thinking about, regardless of which side of the dispute we're entering from. So what has been your sort of insight there? And then I can respond on the institutional side as well.
See, data protection, no doubt, has become a larger issue than it was earlier. We can't run away from it. A large part of now hearings are being conducted online, and they're meant to be private. There is no doubt. But then, the systems that are being used are tools which belong to companies which are very reputed, which have global presence like Cisco, Microsoft, and so on and so forth. And these SOPs at their end, and all of whatever can be done at their end, is in place. It was always in place. It was there before the pandemic. It is there now, and it will survive the pandemic. And those are the best practices that are possible and available in the field of data protection. And we've simply adopted them. So we are today no different than, let us say, Microsoft conducting meeting online. And if the top business strategies can be shared through those very same systems, then we can definitely conduct our business. I mean, piracy and data privacy will forever continue to be issues, but then these are things that you have to live with. I mean, there are documents which get stolen, there are documents which get leaked. Many business decisions reach people who then indulge in insider trading and whatnot. I mean, these are malices which are going to stay. which we have to deal with at a separate level, they can't prevent us from moving forward. So this is, in effect, my response to cyber hacking and whatnot when it comes to conducting arbitrations online.
So for whatever reason, the slide deck, when I click on share screen, nothing seems to happen anymore.
All right. I don't think it should be a problem. Probably when we were backstage, we were better placed. You could share then, and you would have been dropped into that. But nonetheless, drawing on the slides. Kabir, why don't you just throw up some issues that all of us can discuss, or insights that all of us can discuss?
Look, I think, when we're talking about the COVID reality, right, you have one issue that we have touched upon, that is the infrastructural element. You need to have a good internet, you need to have a stable internet, you need to have these computer setups to make the virtual hearing happen effectively. Just a related infrastructural issue that comes up is whether you have the space to do it. Very often when you're living in bigger cities, right, you have limited places. Now, if you're going to be doing a virtual hearing, do you have the liberty to be able to do a cross-examination without people in your family hearing confidential information being spoken about? That's still confidential. You are under legal obligation not to be disclosing that to anybody. And that, I think, remains a challenge, right? Let me just put a pin here to see your reactions.
That's actually a very interesting issue that you mentioned. Just as, let us say, the paralegals or the support staff at our firms are bound by the same confidentiality as we as counsel are, because they are part of the larger they're part of the larger practice, or they're part of the firm which itself is engaged as an entity. With us as counsel having brought our offices to our homes, would our families also be covered by that same oath to confidentiality? I don't know, but it's a very interesting issue that you brought up. I think I'm sure that there is existing law which can be read or molded in a manner that it can be utilized in a manner, or can be interpreted in a manner so as to cover this kind of a situation. But definitely it's a newer challenge. What if you were conducting a call with a client from home, not conducting a hearing? I mean, only the hearing now has gone online. You were still conducting calls when you were at home. There were people in the house who were hearing what you were saying. I mean, there is some level of sanctity to what gets spoken inside of among the family and in a house, and every member of the family respects what is professional and what ought not to be shared with everyone else. But then, definitely, I mean, do we need to legislate on it? I don't know. Rekha, what has been your experience?
Yeah, I mean, I think this notion of this 365 camera is both good and bad, right? Because if we're in a urban space and people don't have the room, I think it's been troubling. In truth, I think that's also why deadlines, for example, have been extended out of just common decency. Instead of making sort of a claim of force majeure, right, where counsel or the party has come and said, I cannot make it to this hearing in light of the fact that we've just shifted and there's no way to run it in the current state I'm in, meaning my home, with limited space and family interwoven into this narrative. And I think the tribunal members get that. They're very considerate about that we all do not have expansive places to go. And I know even some lawyers have taken hearings in New York from Central Park. That's definitely not safe in terms of privacy, even with headphones. But that's the only place they could go if that was the option. And I'll add to this, as we look at pandemic and we look at options that are safe to conduct hearings if everyone wants to be live, one option actually that a party was considering was a party that was going to venue at NYIAC was to take their case to Central Park. And the bigger question became, to anyone that heard this, what are the permits involved? Are they allowed even to do that? How do you deal with privacy? There's no way to soundbox them in an igloo. It becomes unsafe again if you do that. And so I think we're really trying to tackle some interesting issues about how do we do it in the environments we live in, where either where the arbitration is seated or where it's agreed to be venued. And this also becomes important because as we draft further and future procedural orders, a conversation on venue as against seat is becoming more important, because it may be that the venue is remote, or it may be that the venue is somewhere where everyone feels it's safe to gather somehow. But I really think that cybersecurity institutions, towards the question that Avni said, they really, I think, taken this into consideration. They're very selective about the platform they use. For example, Zoom in the beginning, when it was first introduced, didn't have all the bells and whistles. And now there are updates, once a week, if not more. And so I think many platforms have become sophisticated because they've had to, because frankly, otherwise they are in lawsuits in parallel in jurisdictions, including in the US, because of their lack of safety and security. But I think we have to wait and see. Things are becoming more robust. Part of it is also just common sense. If you see a Zoom bomber and you're the one who is the host, you have to bump them from the room, And I know that sounds really basic, but that's part of it. Who is the monitoring force? The institutions are one example to kick somebody out of a remote or virtual room. And I think that's part of it. Let's not fail to use our own common sense as people, in addition to being advocates and well-educated lawyers.
I think a lot of this common sense is now being tabulated and put together as rules. For example, the Delhi High Court recently came up with its virtual hearing rules, and a lot of what you call common sense is effectively what has gone into it. So when is it that an excuse when is it that somebody can be excused for reasons of connection? When is it that they can't be? When is it that they will be deemed to have attended a hearing and the order passed in their presence? By what time will that particular person who later claims that his connection or her connection wasn't great actually complained or informed the court? So all these things are definitely now being woven into rules, and no doubt it's going to be guided by common sense almost in entirety. So yeah, please.
I was just going to spotlight here, for consumption, things like the Seoul Protocol that came out of the KSAB rules in Korea, or the African Arbitration Academy. They were one of the first few to tackle this notion of also what is bandwidth, like what is necessary bandwidth to be able to connect and run an arbitration hearing. I think that we all thought, oh, we know this, but I spotlight that because they were the ones experiencing some issues, or rather seeing it in their clientele. And they said, we have to address this because it's obviously not common sense. And so I will backstop against my comment on common sense. Common sense is not common to the same people. And so it's good that we centralize it, because we're all facing different issues that we think, oh, that's so obvious. And it may be obvious in the US and not obvious in India, or obvious in India and not obvious here. And this to me is the most important aspect, our internationalism, right? That we tote all over the world as we go. We are international lawyers. Our sensitivity becomes even more important in pandemic to appreciate what's common to you is not common to me, and vice versa.
I agree.
Just on that point.
Sorry.
Go for it, Rajat. Sorry, not after you.
In fact, I was going to throw it to you.
Okay.
In the beginning of the session, we had Babita's connection going on and off, and we had a lot of background noise. Somehow during calls, it's become now commonplace to hear children in the background, other noises in the background, and it's all right. So I mean, there is some part of common sense which is common to all now. The world is flattening probably that way. But Kabir, please.
It's a very nice point there, Rajat. There was somehow this fiction that we had pre-COVID. That is, you had your work life where you only worked, you had your home life where you had family, And, the intermingling of the two was sometimes frowned upon. There was this underlying assumption that you leave your family at home. I don't want to
Absolutely.
hear about your kids. I don't want to hear. And that was an artificial distinction, because never were these two watertight bubbles. It is more considerate of us to realize people have kids, shit happens in your life, forgive my French, but we're just more accepting of these realities, which are realities that we're anyway grappling with. Everybody is. So if we just accept it, we're probably better off. So
So how
I
has your
you
experience
great
been,
point.
so how has your experience been with this background noise and arbitral hearings?
My own view with background noise at arbitral hearings has been probably slightly less than at conferences. I think we see it more at conferences, at Zoom meetings. I do think at arbitration hearings per se, parties do, tend to lock the kids, send the kids away. That's, I think, a higher level of of
Decency.
seriousness. But I do think at the same time, if something happens, the person, I think, generally will just apologize, you know, just take a minute's break. Sometimes you turn your camera off, you try to address it.
No,
I think there's greater
would it not?
appreciation.
No, the question. There are two parts to this question. So the other part is, what about the issue of privacy?
Look, there I am concerned. Now, if it's a little kid, I am. Let's just take a situation. You're dealing with an arbitration involving a major celebrity, right? You have family members who are hearing what can be very exciting. This is something people may inadvertently talk about because it is exciting. Now, what do you do in that situation? My own view is bar councils throughout the world are not going to look at that favorably. The fact that you're doing it in your apartment doesn't change your rules of privacy. You are still bound by the same rules. There is going to be no relaxation on your ethical standards. That is, in my view, a trickier question. When it's just the issue of tiny toddlers, which you often see, right? Suddenly a baby pops up on the screen or comes in your lap and, wants to play with you. I think, there is, in fact, in my view, always generally an awe moment, where everyone's like, oh, this is so adorable. But that's my own view. I could be wrong, but this is how I look at it.
Sorry, Rekha, what's your view and what is NYIAC's view on?
So I'll make the disclaimer necessary. All of the things that I think Kabir and I are sharing are on our own behalf and not representing our institutions or firms.
Which is why I asked the question in two parts.
Yeah,
So-
no. But you know what? I'm going to drop in, I guess, an additional fact to the pattern, right? What we're also seeing as we've shifted to this online platforms is clients, right, joining more readily because now it's no longer a barrier. And so what does it mean towards the seriousness of a proceeding where your client is now often part of the process in a much more visceral and online way? They join all the preliminary conferences. They were always invited before, but they just never did. So now there's a monitoring factor, right? The advocate is on, defending the client. The client is also on now, part of the process. Does it make the process better or worse towards these words we throw around constantly, towards economy and efficiency? In addition, I guess, to due process of law, right? These are always the things we hear in sequence. And so I sort of drop that in the hat, affirm the fact that we're seeing more clients on average joining not only the hearings they were always a part of, usually in some format, but not the pre-hearing conferences leading up to it, or even the post-hearing conferences. And so I pose the question actually back to each of you, shifting a bit from privacy to more inclusion, where we include the clients more. How are you finding that as advocates? How are you addressing it? How are you talking to them also more and messaging offline before you get to the pre-hearing conferences? How has your experience been?
So I usually have a call with the client beforehand to inform the client of the etiquettes that are expected during that particular hearing or conference or whatnot. Other than that, I think the larger my larger view is that this brings about a great amount of transparency. It brings about a great amount of accountability, and that automatically leads to greater efficiency. And therefore, like I was saying earlier, this has been it's been a sad year, but it's been a year of great learnings. And a lot of courts now, for example, court proceedings now are being streamed online. A lot of court proceedings, for example, the links are available, let's say to me, the lawyer. I share it with the client and I have no control thereafter on whom it goes to. So there is a much larger audience to that same court hearing than there was earlier. So, clearly a lot of what we were fighting and, weren't sure how to deal with has been thrust upon us. And we are reacting to it. And we are reacting to it in a manner which is guided by common sense, guided by experience, is dynamic. But then at the end of the day, we're making progress. And this progress must not only continue, but it should be retained. The benefits that we have from this particular year must be retained. I think Axel has joined us, which is great. So,
Fantastic.
Just welcome Axel. Hi, Axel. Can you hear us? Hi, Axel.
While we wait for Axel, let me just echo what you said, Rajat. I fully agree with that view. I think this virtual reality with clients participating sometimes results in a more efficient. Lawyers love motions practice, right? We love to, whenever you can bring a motions practice, disagreeing with what your opposing party has said, we tend to do it. That's our gut reaction. Clients don't like that, very often for them, this is all coming at a cost. This is probably delaying things in ways that may not always match their expectation. Having them present, I think, puts a check on counsel. So I think the point that you made is a great one. It's one that I share. We're probably going to see a system where clients have a greater say in every step of the process.
What I've also seen, just adding to that before we go to Rekha, it acts as a check on the tribunals also. So the tribunals,
Yep.
It's not that the tribunals are always the most efficient. They're very happy to have, let things be heard on the next date and so on and so forth. Let's say the client is attending every single hearing. Now, at the first instance, if the tribunal wants to give a date, all right, a date's given, a date is given. But the next time, when they see the faces of those same people in the conference, and they tend to push it, it comes back to haunt them, and they're not able to do it very easily, because then the client is going to come to me and say, let's find an alternative. We have to get out of this, or at least make a point with the tribunal. So I think it's added overall efficiency to the entire process, and I think that should always be welcome.
Fantastic.
That's also made the life of institutions like NYIAC easier.
Yeah, I mean, it's this funny thing, right? You talk about institutions, and many institutional rules, what you find is that they give great jurisdiction and leeway to the tribunal. Because ultimately, even though it's an institutional award, it's the tribunal's award. And so I think there's a lot more sort of curiosity of process. I think institutions welcome the client being on, as well as the outside and in-house counsel collectively all being on. And I do query, does it make us more efficient? I think if there are more people, it can. because we have to figure out what the process will be like. But when there are too many cooks in the pot, so to speak, it could also create some turbulence. And so, on Thanksgiving Day in the U.S., I make this joke because you have to try to limit it if there's going to be any food on the table.
True. So how are you coping with this complete lack of paper?
I was waiting for this question, actually. I'm going to give it to Kabir first, and then I'll just note we both, in full disclosure as well, are members of the steering committee of the Green Protocols. So we're definitely pushing our different realities to go paperless. But with that, Kabir, why don't you talk about it from the counsel and arbitrator side, and I'll address it from the institutional side.
Yeah. So other than paper companies, who would not want to go green?
Yeah, this tends to be a generational thing.
I'm not on the committee, but I'm with you on this. Sorry.
No, I just echoing what you said. Look, printing things, there's a cost. There's a logistical thing. You have to page check everything, make sure everything's. Most of the arbitrations we do tend to be large and voluminous. If you're in cities, especially in a city like New York, we have very limited space. Where am I going to put all these binders? So I am personally of the view this is a positive development. And I just think, so the committee that Rekha spoke about, we meaning not Rekha and me, but our team did a study, and the assessment done was that for a mid-size arbitration, we're not talking of a large one, you need 20,000 trees to offset the carbon imprint. That's terrible. I mean, we should be doing so much better. I recall early, when India had the lockdown, right? People in Delhi had this observation. I wasn't there. So this is something, Rajat, you can talk about probably. But, you could see the blue skies, right? There was this articles in the press talking about how it was in some senses resetting environment. And that is something, as you have been talking about, it's a positive. The less we fly, the less we have to travel, the less we have to print things. There's a very positive impact for the environment, and we should aspire for that. I'll stop here and open it back to both of you to see your comment.
I think I completely agree. And but I am a little apprehensive whether paper would be done away with completely. Because what I have realized from experience is that in addition to circulating everything online and so on and so forth, arbitrators still say, all right, in any case, make a copy. When we go back to hearings, we'd probably need one. So, copies do get made. And it's the sad reality. But I think we are on our way to go paperless simply for the reason that even if my office could possibly store all binders, my home cannot. Even if my home can, I would not want it to be stored with binders. I would not want my home to be covered, every square inch to be covered in binders. If I'm in my office, all right, it's acceptable, but not at my place. So there is definitely a move towards going paperless. There is a possibility, but I'm a little apprehensive whether it's actually happening.
I would agree with you there. I mean, I'm not up. I wanted to go there. Are we yet there? I think no.
I have this. I don't know. I tend to go where most people tend not to. So I think let's welcome Axel again. Axel, can you hear us? Unfortunately, a frozen screen. So Rekha, what's your experience been with us being able to cut out travel? I mean, that also, of course, has a green aspect to it. But then other than that, it's also got that efficiency aspect.
So I think this is a really, big point, not only about carbon footprint, but to me, it's an opportunity for access, right? And we can look at it in different ways. We've been having a lot of conversations about access for junior lawyers, where it was always a burden for them to have to travel. Was that a cost that could be included? And now in virtual, are they able to get more access to proceedings, to build their knowledge base? And of course, it will depend on whoever is the team leader, the senior counsel on that case. But I think by and large, we're seeing options for access available for younger lawyers. And that's a great thing, not only because it limits, again, that travel cost. And I think the point that was made early on, one international flight ticket could be the amount of money it takes to make sure an infrastructure, or that everyone has a necessary laptop or laptops and a stable connection in parallel with their WhatsApp or whatever the counsel team is using to communicate confidentially. But I really think something we have to think about really critically is, how are we, as we've pivoted to this online, virtual, or remote world, how are we going to make sure that we're offering opportunities to younger lawyers so they feel that they're still able to understand, to learn, to get speaking engagements, to network? We've all shifted to virtual really well, but it does not, it does not have the same impact as getting to meet somebody in person, in safe times, to give them a hug, to have this moment in the same time and space together. We do it in virtual for sure, but let's just admit it's not the same. It's not the same human connection. But how are we all going to allow, I think, for junior lawyers, as well as our own, ilk and our own stage lawyers, that we're meeting, that we're connecting, in addition to just our proceedings, which are super important. But how are we giving a mic to others in addition to ourselves as we keep platforming? This, to me, is a very large question, because it keeps coming up. What does networking look like in the new normal, in virtual? What does advocacy look like in terms of how many boxes can you have on a screen so that the tribunal gets to see them? How do you socialize, your talent beyond just the senior advocate who's running the case? And I think we have to think about that, as we keep going forward. Like, how many tiles can fit that's helpful? How do we share the mic? And I just put those out as global questions to both of you as Axel joins us.
Oh, great. Hi, Axel. Axel, we can't hear you, unfortunately.
We can see you.
I hope you can hear us. So we'll continue the discussion. Just try and mute yourself and then unmute yourself again, please. So Kabir, in addition to access, the issue of access or the point of access, how do you as a firm see cutting out travel?
Look, cutting on travel it depends who you are asking. I think that's the question there. On the whole, I think there are a lot of advantages. The query really is, if you have a multi-billion-dollar dispute with 15 witnesses, 9 experts, there are like thousands and thousands of pages of documents. How do you then do it virtually? That is a reality. I don't know we have a good answer. And just a related point that I'll flag for consideration. Let's imagine a likely situation. You have a party from Australia, India, France, the United States, and Chile. Parties, arbitrators, combine this. We have now gone from one end of the world to the other end. To find a convenient time to do the hearing, somebody is going to, pardon my French, get screwed. Somebody is going to have to stay up all night. Somebody's going to get inconvenienced, or you're going to have a hearing spread out over months because you're doing it for 2-3 hours. How do you deal with that reality? I don't know if we have a good answer. I think, look, every solution, you can come up with some ways to address it. But this reality and the reality of, these mega large disputes, I think those become to me trickier areas for online/virtual platforms as we are today.
So,
I'll just pause.
Sorry, please go on.
No, I'm pausing here. So back.
So I agree. Travel ought not to be and cannot be cut out completely. But of course, in a situation as you pointed out, I think it's the prime example where proceedings must necessarily be conducted online. Except probably one party needs to travel so that time zones match. I have done one such matter where we took turns staying up the night. So people took turns. So if it's for, let's say, my turn to argue, I argue during my day, and the opposite party, which is at the other end of our cycle, stays up the night to take notes. When it's their rebuttal, they argue during their convenient time, and I stay up and then take points for my rejoinder to follow or my written arguments to follow. So it's always possible, but no doubt, travel ought not to be cut out. One important thing with regard to travel that I thought must be mentioned is the cost. I think we touched upon it earlier. We touched upon it from the standpoint of infrastructure and how possibly infrastructure could be made good by cutting on travel. But the enormity of the cost, let me just give you an example. One of the largest consulting companies in the world, not naming the company, effectively they had an internal meeting in which it was pointed out that we can still go ahead and hire the number of people that we ordinarily do because we would not be traveling this year. 25% of everything that we spend is travel. So it turned out to be business as usual for them, simply for the reason that they were not traveling any longer.
The cost factor is amazing, right? Because with travel, you have to factor in, it's not alone travel, it's room and board, it's a socializing that we have to do and that we do with our meals. I mean, all of that now is like in-house.
That's true. It's your coffee, your electricity.
Yeah.
And NYIAC takes the benefit.
Yeah, well, and that's why the joke is made, on a much lighter note in networking sessions. People are not allowed to complain about their drinks anymore because you brought it. Like, whatever it is, you provided it. But it's that same notion. We are achieving in the worst of times, let's just admit it, right? Economy in a way because every dollar does count. As we see small businesses and even larger businesses go under, having issues with, payroll and otherwise, like, money is a commodity that is not, so easily found. We see that even in the requests for third-party funding, as I mentioned before. I mean, the uptick is huge. Not to say that the third-party funders are funding all of these. Their due diligence process is very high level. For many of them, they now have, international litigators and arbitration specialists who have gone from big law into that. And they're really vetting with a tenacity that's important to note. But where money becomes so important, where clients may not have it, right? But due process is something they still deserve. Everyone deserves it. How do you achieve that? And I just think where we can save by this notion of we don't have to travel, we don't have to spend, we don't have to. Cities may realize it, right? May realize the effects of the lack of our spending those dollars in major seats. But it's forcing us to look at, how did we line item costs? When you make your plea for costs, right, at the end of a proceeding, what is it involved now? And is it drastically lower or not so much? I mean, those are the metrics I think we're going to have to tease out and have a really candid conversation about to see the impact and the effect. because it always lies, right, in those kinds of metrics. As lawyers, we want the numbers, right? We may need an expert consultant to tell us what the numbers mean, but we want the numbers because that's a quant factor that we can identify with.
Two very interesting points you make, and I'll open it up to. I think I'm hoping Axel can join this time. One is networking. So, how has everyone's experience being networking virtually, and is it efficient? Number two is your issue with regard to you touched upon how venues become important. I think let's delve a little bit deeper into this because seat always was the one thing that was negotiated, discussed, but venue nobody cared. But today venues become very, very important. You're right. So Kabir, could we have your comments, maybe your insights on both of these issues?
Sure. I mean, on the latter question, venue versus seat, I still think parties spend a lot of time trying to agree on the seat. That is a pivotal question. Everybody will agree, no matter what bedroom we are in. The seat is London, Paris, New York. I still think we're going to agree on that. Venue itself, I think personally, has become less important just because we recognize everybody's all over the world. On your first question, networking, look, there is nothing like meeting people face to face, nothing like being able to actually break bread together, chat. I don't want to undermine the effects of that, but life is all about trade-offs. I think had COVID not happened, we would probably not have met, Rajat, you and I.
I completely agree.
There is some value in us being able to meet like this, to have this dialogue, to connect. And I don't want to undermine that aspect of it. There is greater at least for us, look, the point you make of suffering is totally true. Don't want to undermine that reality. But for us as lawyers, we have been able to dialogue in ways that we never were. And that is nice. We realize how COVID affects all of us, no matter where we are. These realities we are talking about are common shared experiences. So I do think there is a trade-off to the in-person. Overall, I still think there's something nice coming out of this, something that I value. So I will stop here, welcoming your reactions.
I think without doubt, and I am repeating this, I think the second time or the third time in the session, for the first time for us lawyers, the world is flattened. And as I was mentioning before, probably not at the session, but earlier. So I read this book by somebody in a tech company, written about 15 or 20 years ago, and how he spoke about Bangalore emerging as the new Silicon Valley, and the book was titled "The World is Flat." So just as the world flattened for tech companies or tech businesses 20 years ago, it's for the first time flattened for us. Unfortunately, Axel has not been able to join us today. He can hear us. We can see him smile now. We can see him shake his hands as well. But let's discuss, because he wanted to discuss, and I also was very interested in discussing what are the innovations you see coming out of this. What are the takeaways, and how is it that arbitrations can today be conducted innovatively in these times? I mean, the idea at the end of the day is to prevent loss of time. I mean, time was a commodity that we'd blown up so much in our head that today, it is once again about how not to waste time. So, Rekha, can we begin with you?
Sure. Yeah. I mean, innovation. I mean, I think a lot of what we've been talking about have been innovations. The tech reality, the 365-degree camera for online arbitrations, the protocols, I think in truth, another innovation is that people cannot sit in Zoom for as long